After separation, it seems that a lot of parents have difficulty getting information about their kids, whether it be from schools or healthcare providers or in relation to activities or from other agencies that are involved in their kids' lives. This is a question that I am asked a lot and is a topic that several followers of this podcast have requested. I have also heard about a lot of complex applications of several laws to access information. That shouldn't be necessary. Getting information about your kids after separation should not be that hard. Difficulty maintaining that information may be an indication of parental alienation. So how to use the law to ensure that you know the important information about your kids is the topic of this episode of the Ontario Family Law Podcast. I'm Schuman, a certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficulty parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. If this episode covers topics that are important to you, then you will likely find the book very helpful. It is important for parents, especially parents who play an active role in their children's lives, to be able to access information about their children. Obviously, parents want to know how their kids are doing in school, but knowing about a child's medical conditions and history can be critical when getting medical help for a child, especially in emergencies. But every involved parent wants to know about their children's activities and their progress in those activities. None of that should change just because parents have separated. Although in high conflict separations, unscrupulous parents can find ways to push another parent out of their child's life, and restricting access to information is one way to do that. In episode 75, I went over when it is legally permissible for one separated parent to push the other out of their children's lives, and the potential consequences when doing so is not legally justified. There are over 100 episodes that cover the range of important family law topics, so make sure you subscribe to this channel. Like this episode to see more episodes on similar topics, and hit the notification bell to find out when the latest episodes come out. Also, you can get a lot more in-depth information on Ontario family law topics by getting a copy of my book. The family laws that apply in Ontario are supposed to help facilitate separated parents getting information about their kids. Those laws take a very child-centered approach, and obviously for parents to be child-centered, they have to know about their children. To understand those laws, it is important to understand that Ontario no longer has legal concepts of custody and access. Judges do not like when parents use those antiquated terms because they focus more on the parents than on the kids. Instead, the laws look at what parenting time the children have with each parent and how decision-making and other responsibilities for the children are divided between separated parents. To make sure you understand how the new Canadian divorce laws and Ontario family laws address issues related to children and parenting, check out episode 59, which goes into that topic in detail. Or get my book, which covers it in even more detail. The simple reality is that no parent, but especially separated parents, should have difficulty getting information about their children. There are some times when things get a little bit more complicated, but in most cases, parents are just entitled to get that information. Section 20 sub 5 of the Children's Law Reform Act says that any parent with a legal entitlement to parenting time is legally entitled to make inquiries and to be given information about the child's well-being, including in relation to the child's health and education. So everyone who has parenting time with a child has a right to get information about their child, unless a judge orders otherwise. Judges are unlikely to do that because of the importance of parents having information about their children. It is only in extremely rare situations where an abusive parent finds a way to misuse that information that a judge might make such an order. It is likely that a judge would also deny allowing such a parent to have parenting time, which would cover information access too. But that almost never happens, except in cases of severe abuse or parental alienation. Privacy laws, access to information laws, or any other laws do not have application because the Children's Law Reform Act addresses the access rights for people with parenting time specifically. There are very few limitations to that law, and I will discuss those in a moment. Really, All a parent should have to do is tell the agency, institution, or person who has that information that Section 28 sub 5 of the Children's Law Reform Act applies. And so the parent requesting the information has the same access to information as the other parent or parents. It really should be that simple. If someone has parenting time, they have access to information. As a side note, as I covered in episode 78, grandparents, step-parents, and others can ask for parenting time, and if those people get parenting time, they will get access to the information too. So if that sounds like it may apply to your situation, check out that episode too. When can an agency, institution, or professional involved in the child's life deny access to information to a separated parent? First, as I noted, a judge can order that a parent not have access to information about a child. That most often happens when a judge has to impose extraordinary remedies to stop one parent from alienating another or abusing a child. But that is not going to be an easy order to get. Second, I should note that the Children's Law Reform Act gives everyone with parenting time the same right to receive information. It does not necessarily compel an agency, institution, or professional to provide that information. Publicly funded and other institutions often have a separate legal requirement to provide information. For example, Section 266 sub 3 of the Education Act gives parents the right to information that a publicly funded school keeps about a student in its records. And Section 300.3 of that Act requires that a principal provide information to parents of students who have been harmed. So that information must be available to every person who has parenting time. The Education Act does give students who are 16 or 17 years old and who have withdrawn from parental control rights to control their information as if they were adults. Also, things are very different at private schools. In episode 35, I explained how many of the rules that apply to public schools do not apply to private schools, even though parents think they do. The rules for private schools mostly come from the contract that the school has with the parent or parents who signed that contract. And some private schools will only share information with the parent who signed the child up and paid the tuition. Ontario law has almost no requirements that private schools provide information to parents and does not explicitly require that a school provide all that information to all of the child's parents. So it is possible for a parent who signed the contract and paid the tuition to tell a private school not to share that information with another parent, although that may still upset a family court judge. If a parent cannot get information about their child from a private school, then it is time to consult with an education lawyer or a family lawyer, and I happen to be both, about how to compel that release of information. There are some options which might escalate to going to family court to get an ex to authorize the release of the information or taking the school to civil court. Things are also more difficult when a child turns 18. When a child legally becomes an adult, the right to access to educational information moves to the adult child, and that adult child can decide who gets that information. That child can decide not to share information with one or both parents. However, that may not be the end of the story. As I explained in episode 54, and also in my book, Canadian law requires a parent to continue paying child support for a child who is over 18 years old if that child is enrolled in a full-time program of education. Children who are not attending school full-time do not qualify for child support, so a child may have to provide proof that he or she is actually attending school full-time. And as some children have enrolled in school just to get child support and then have not gone to class, a family court judge may order that a child prove that he or she is actually attending school full-time and is making a real effort to complete that education. In these cases, a judge may make a child prove that he or she is attending and putting real effort into a full-time education to continue to receive child support. So that child may be compelled to provide information about his or her education. There are more considerations, so check out episode 54 or my book for more detail. I have referenced several other episodes of this podcast in this episode. For more information about other family law topics, please subscribe, like this episode, hit the notification bell. You may also want to pick up a copy of my book. In addition, you can get a lot more Ontario family law information on www.schumanlaw.ca. And on my social media feeds, check out my Facebook page, follow me on Twitter and Mastodon at @SchumanFamLaw, and find me on LinkedIn, and also on Threads. Also, check out in the description for how you can contact me. Health records are another area where things can be more complicated too. The disclosure of health information is governed by the Personal Health Information Protection Act. That Act says that any person who has legal capacity to make decisions can decide whether or not to consent to the release of health information. Section 23 sub 3 specifically says that children can be capable of making such a decision, and that if the child is capable of making such a decision, the child's decision overrules that of a parent or guardian. Put simply, children who understand the information around giving or withholding consent to access to health information and the consequences of such decisions get to make the decision about whether their parents get to see that health information. While the Act makes reference to age 16, that age is not a definite line. Ontario's Children's Hospital started inquiring about a child's wishes by age 12 and respect the wishes of younger children who are capable of making such decisions. But, as they went over in episode 100, to be respected, a child's wishes must be freely made and not the result of manipulation or of a parent or anyone else. So parents have to respect and live by the healthcare decisions of their children as long as the child understands the decision and makes it freely. Any parent with parenting time has the same rights as a child's other parents to receive information. Section 20 sub 5 of the Children's Law Reform Act should be all that most parents need to reference to access information about a child. But there are limitations for adult children, for private schools and other private institutions, and for health records. Still, it is important that parents receive information about their children's education, health, and welfare that allows parents to make the best decisions and protect their child's interests. If you are having trouble accessing information, please feel free to contact me using the contact information in the description. Remember, you can also get a lot more family information, including information to let you make the best parenting decisions after separation, or to better understand how finances work after separation or divorce, or if you want more guidance to make those difficult types of decisions, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook Store, on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. Check me out on social media, and please subscribe to my YouTube channel, and hit the notification bell to keep up to date. You can also get the audio version of the Ontario Family Law Podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They are also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.